I introduced yesterday a very important decision by the Fifth Circuit Court of Appeals upholding the Texas law that outlaws social media censorship. This is a law, by the way, with large implications for what other states might do. It has direct implications for someone like me, since Debbie and I live in Texas. And as a consequence of this law, if someone like me is banned by Google or banned by, which is to say Google owns YouTube or Facebook, we can sue. And I want to put these social media platforms on notice. We will sue in the state of Texas because they're not allowed to engage in viewpoint discrimination in this state. They will be forced to put the person that they ban back on, and they're going to have to pay their legal fees. And frankly, I anticipate that thousands, if not hundreds of thousands of people will be filing these suits if this Texas law stands at the Supreme Court level, which I think it will. The only recourse for the social media platforms is to appeal to the Supreme Court. They may not even take the case. But if they take the case, I think it's likely that they will affirm the Fifth Circuit Court of Appeals, in part because of the sheer clarity and even beauty of the reasoning of this case. Andrew Oldham is the judge who writes the opinion, and he begins by just blasting this idea that these platforms are somehow like newspapers, exercising editorial judgment over everything that they put out. He says, quote, "The platforms are nothing like the newspaper." He goes, "Unlike newspapers, platforms exercise virtually no editorial content or judgment. The platforms use algorithms to screen out certain types of content. Virtually everything else is posted to the platform with," this in italics, "zero editorial content or judgment." And think about it. You post on Facebook, by and large, that's what you think. It's not what Facebook thinks. And so right away, the judge just ridicules this idea that Facebook is like the New York Times. Second of all, the judge basically goes on to say that these platforms all went to Congress and said over and over again, quote, that they serve as conduits for other parties' speech, that they cannot take responsibility and do not endorse the content on their own platforms. And on this basis, they got a special legal protection. This is Section 230, saying they can't be sued for the content on their platform. Why? Precisely because they're not like a newspaper. They don't exercise editorial control. They let people post whatever they want. So it's the poster's responsibility, not YouTube's responsibility or Facebook's responsibility. And the judge goes, see? They are admitting themselves that they are not like newspapers. They are admitting themselves that they are platforms, not publishers. And so they can't then turn around and say, well, listen, we have the right to exercise editorial control, because after all, we are like the New York Times. In fact, interestingly, the social media platforms appeal to cases involving newspapers and say, look, the newspapers are allowed, they're private companies, they can publish whatever they want. And the judge goes, yeah, but you're not a newspaper. So those rules don't apply. Now, Texas has designated these social media platforms to be, quote, common carriers. This is a very important idea. A common carrier is a business that engages in a certain type of conduct that affects the general public, and in some cases is the only way for the general public to be able to engage in a certain type of commerce. Let's take, for example, the idea of a company that by itself has a contract, let's say, to run a ferry across a river. Now, this is the only company that runs the ferry. Can that company decide arbitrarily that it's going to not allow certain people to cross, even though they're willing to buy a ticket to the ferry because they don't like them? They decide, we're not going to let anybody from Ohio use this ferry. We're not going to let blacks use the ferry. The ferry is only going to be limited to people who are born in the United States. The answer is they can't do that. Why? Because they are common carriers. They have an obligation, and by obligation, I don't just mean a moral duty. They have a legal obligation to serve everybody. There's a long line of cases on common carriers. They have a, quote, duty to serve. By the way, this concept was imported to America from British law going back centuries. It applies to stagecoaches, barges, innkeepers. Later, it applied also to the telephone and the telegraph. Think about it. Can the telephone company decide, we're going to exclude people from service because we just don't like the kind of things they say? Yeah, we're not going to offer service in West Virginia. Those people use a lot of obscene language on the phone. Can't do it. They're common carriers. Interestingly, and I didn't know this history, in the opinion, we see that a number of these telegraph companies were using the telegraph to discriminate against ideas they didn't like. In fact, even to sort of limit candidates that they didn't like. And all of this led to many states passing laws basically saying that there can be no discrimination on the telegraphs. These telegraph companies cannot use their muscle to tip the scales politically, to ban certain people, to restrict certain people, and so on. And all of this law is now imported here and is being applied by Texas, by the appellate court, the Fifth Circuit, to say that Texas has every right to designate these platforms as common carriers. Why? Because they are. They are the public square. And quote, in that sense, the platforms are no different than Verizon or AT&T, which means that they are held to the same standards. And so the conclusion here is very simple, that these platforms are trying to take the individual right to free speech from the First Amendment and transmute it into a corporate, remember the left has itself told us corporations aren't individuals, into a corporate right, not to affirm free speech, but to suppress it. And in a marvelous decision, the Fifth Circuit Court of Appeals has said, not just that that's not nice, but that's against the law.